controversy over police use of tasers in Key West and Monroe County has recently received a lot of attention. The results of separate investigations in two high-profile taser cases in the Keys have just been announced. 4 months ago, we published this cell phone video showing an unidentified man who'd been tased on US 1 just north of Key Largo. After the clip went viral, the Office of the Inspector General conducted an investigation. A review of footage from 2 additional video cameras led the Inspector General's office to issue a finding that the repeated use of tasers in this case constituted excessive force.
Oh God, he's all limp.
Driver, open the door! Open the door! Open the door! I'm giving you a lawful order to open the door, or I'm going to break the window and get you out. Open the door.
Why do I have to go inside the car? Why do I have to go inside the car? I will answer any questions. I will answer any questions.
One more time. Stop resisting. Out. Where are you going to go?
I got tased again. Ow! Ow! You don't let me. Don't let this happen. Don't let this happen to me.
Stop resisting. Stop resisting. You understand?
Okay, I'm going to stop.
Are you going to stop again? Are you done? You're going to do it again?
Please don't.
Are we? Listen to me.
I hear you.
One more time.
I'm going to stand you up. Don't do it.
I'm going to stand you up.
Yeah.
And put you in that fucking car.
Okay.
You fucking twitch, you're going to get worse than a fucking taser.
Okay.
So stand your happy ass up. Get up.
Okay, I'm doing it. I'm doing it. I'm doing it. I'm doing it.
Get him up.
I'm doing it.
Get inside the car. Get in the car.
And then there is the case of a catastrophic taser injury in Key West. This horrific zombie-like footage shows Matthew Sean Murphy being tased on Duval Street. 4 years ago, those fateful 5 seconds at 50,000 volts landed him in critical condition at a Miami hospital. He's been there ever since, in a vegetative state, unable to walk, talk, or even eat on his own. This week, in Key West, the Citizen Review Board was to decide whether Officer Mark Syracuse, who had tased Matthew Murphy that night, had used excessive force. Matthew's fiancée, Marie-Anne Ruiz, complained to the CRB that Officer Syracuse had not announced himself and had shot Matthew without any warning. This is board member Tom Malone, quoting the Florida statute regulating police use of tasers.
Before the taser can be used, the person being tased has to escalate their resistance from passive to active. And it seems to me, based upon the evidence in the file, that Murphy was not aware of the officer's presence. And if he was not aware of the officer's presence, then it seems to me then he couldn't actively resist the officer if he didn't know he was there. I mean, granted, Murphy was the aggressor. He responded to very hurtful remarks inappropriately, which is unfortunate for him and his family. But that doesn't excuse the officer from following state statute, and it appears to me that Officer Syracuse did not. I don't think the statute was followed because Murphy was not aware of Syracuse's presence. None of the witnesses claim to have heard Officer Syracuse announce his presence or give any kind of a warning prior to the use of the taser. And in looking at the taser video, it appears to me that I couldn't hear any words from Officer Syracuse until after the taser was deployed, when he instructed Murphy to turn on his side and put his hands behind his back. Prior to that, there was nothing. Just the crowd's reaction to the taser and Murphy falling to the ground.
Anything else?
Having now read the actual statute, I think it would be helpful to kind of walk through this thing incrementally. And what I would point out is the statute uses the word must. Doesn't say may, must. And when you're interpreting contracts or interpreting law, must is the same thing as shall. Okay? So we start with the premise that whatever follows the word must is mandatory, not discretionary. So what it says is an officer who uses a taser, they call it a dart firing gun, must involve an arrest or a custodial situation during which the person who is the subject of the arrest or custody escalates resistance to the officer from passive physical resistance to active physical resistance, and the person has the apparent ability to physically threaten the officer or others, or is preparing or attempting to flee or escape. So if you look at this statute and you read it literally, in order to use a taser, the way I read the statute, there must be an arrest or a custodial situation. In other words, where an officer is attempting to take someone into custody or has them in custody. Those are the two mandatory predicates to the use of the taser. Either there is an arrest or a custodial situation. If you have either of those situations or both, then you look at whether or not the person who is subject to the arrest or custodial detention has escalated resistance to the officer from passive physical to active physical resistance. So in my mind, the issue for the board is, was there a custodial situation? Because clearly there had not been an arrest made at that time. I think the evidence is very clear that there was no arrest when the taser was discharged. And so the issue becomes, was there a custodial situation at the time the taser was discharged? And I can't answer that question for you, but I think the focus needs to be on those two mandatory requirements that are the predicate under the statute for the use of the taser. And while it's true that the police department has guidelines for the use of the taser, those guidelines cannot violate Florida law.
However, Sergeant Tripp, Chief of the Internal Affairs Division, voiced his frustration over the direction the discussion was taking.
Objective reasonableness is the standard by which force is used in America by police officers. I implore you to educate yourself reading Graham versus Connor and the definition of objective reasonableness. If you are not familiar with that term, intimately familiar with that term, you have no business making decisions in use of force. You might say that because the statute says resisting, that you might consider it unlawful behavior, but it doesn't meet any threshold for excessive use of force. And you find that the unlawful behavior is interpreted by the prosecutor, who is the state attorney. Again, I say your argument is with the wording of the statute. In addition to intimately knowing what objective reasonableness is and having a familiarity with Graham versus Connor, which is the defining case law for use of force in America. By the way, we don't use the FDLE matrix anymore. It is strictly objective reasonableness. You've really got to do that. Now, in addition to learning about that, you need to find out what different courts have determined is objectively reasonable. And I think that if you do that, if you read the case law on taser usage, that you would find whether you warn the person or not, a person that's actively engaged in fighting can be tased, and it will hold up in court. Thank you.
In Graham versus Connor, the Supreme Court said, "The reasonableness of a particular use of force must be judged from the perspective of a reasonable officer on the scene. Since 2009, the taser manufacturer warning has indicated that the taser is potentially a lethal weapon. When Officer Syracuse chose to fire his taser at Murphy, he had been forewarned by the manufacturer of the catastrophic consequences that could and did occur. He was also prohibited by state statute to fire the taser without giving Murphy an opportunity to stand down and comply. He was responding to a misdemeanor single-punch fistfight between two men. No weapons. Under those circumstances, would a reasonable officer deploy a lethal weapon rather than obey Florida statute? The CRB thought so, agreed with Syracuse, and voted 4-2 to deny Murphy's fiancée's complaint. The family has filed a federal lawsuit. The issue ultimately will be decided by a jury. This week, California attorney Peter Williamson, famous for securing multi-million-dollar verdicts in taser-related injury cases, has filed a lawsuit on his behalf against KWPD and Officer Mark Syracuse, who fired the taser that night. It was 3:40 a.m. Matthew Murphy and his fiancée, Marie Annalise, were walking back home when they were stopped by a local couple, Jason Moffitt and Beverly Anderson.
I was like, the white guy, he had long hair. And he said, nigga lover. And I turned around and I was like, I was so shocked, like, nigga lover. Like, I've only seen this on TV. Like, I've never in my life had anybody said that to me, made me feel like that.
The time, 3:41 a.m.
Key West 911.
Yeah, I'm right here in the corner by Wendy's.
Okay.
And we got a bunch of goddamn fucking niggers out here fucking starting some shit with me and my dog. I'm fixing to go to my hotel room and they need to get the fuck out of here. We're right here in front of Wendy's on Duval Street.
It was over the white guy being with a black girl.
Which would have been what? Like
she probably used nigger, and
right.
I'm not sure. There's a white boy with a nigger. I don't know, but yes, Beverly instigated the fight.
So automatically, Matt, started arguing with him, because you can't talk to my girl like that, like. And then the lady that was holding the dog, she's like, I'm gonna beat your nigga girlfriend ass. And then we all started arguing, and then the dog started barking because people's arguing. He's gonna bark. And then I'm in the middle of him like that. I'm standing in front of the guy. I'm like, calm down, it's okay. You said what you had to say, whatever, And then I turned back. Matt is on the floor. And he's like this.
You never heard the police say anything?
I never heard the police said anything. Because if he would have said, hey, what's going on? We both would have stopped, arguing, and we would have explained to him, they are being racist. In the morning, I started crying again because I'm like, maybe it was a dream. Maybe Jackson Memorial Hospital called me 8 o'clock in the morning and say he's about to go in surgery. He had a brain bleed, and they have to take a piece of his skull out. And not too high, but go. Throw it up. Throw it up. You can't even do it.
Marie is now left alone, raising their son, Caden, born just a few months prior to the incident. We were told that Matthew can still communicate by blinking his eyes, so we went along for a weekend visit at the hospital. We were not quite prepared for what awaited us. Matthew had just emerged from a bout of pneumonia induced by his total inability to move. The blinking of the eyes for yes and no certainly was not working out that day. His chart said vegetative state.
He's 28 years old. I don't think I'll ever have him back again.
According to Amnesty International, tasers had already caused over 500 deaths by February of 2012. In a 60-minute interview, Rick Smith, co-owner of Taser International, explains the inevitable random risks of a taser blast.
On the cases where taser clearly caused a death, and there's over a dozen of them, and those are injuries related to falls, where the taser caused a fall, some of them from a high place, some of them from people standing on the ground and people fall down. Some of them are going to hit in just that absolute wrong way and sustain a lethal head wound.
So, how does one define the reasonable use of a weapon that is safe most of the time, but can still maim or kill at random? 19-year-old Danielle Maudsley did not survive. To address the rather unpredictable effects of taser use, the manufacturer and legislators have tailored a new legal concept. They shift the liability from the user to the victim. As long as the victim has been given an opportunity to choose not to be tased, he or she must assume all the consequences of a taser blast. In fact, Florida has adopted this concept. An officer can only fire his taser when a suspect is actively resisting the officer. So here comes the multi-million-dollar question. Was Matthew Murphy given a choice? Did he actively resist the officer, as is claimed by KWPD? Or was he fired upon without even knowing the officer was there? This is Jason Moffat, the man who was arguing with Matthew Murphy the night he was tased.
He did not say that it was QSPD. He did not say cease and desist. He didn't say anything. He rolled up, tased the kid from the back. The child never got to see the officer, never knew that the officer was there, never knew what hit him.
I'm Beverly Anderson. And the cop had came around the corner on a bicycle, and he didn't say, stop, police, anything, nothing. He just pulled out the taser and tased.
Could the kid have seen the officer?
No.
But you didn't see them coming?
No.
They came from behind you?
Yep, they came from behind.
They were behind Matt?
Yep, they were not.
But the chief of police claims that the officers issued multiple warnings.
The officers responded to that situation and were giving verbal commands for the people to separate and stop fighting, and they refused to do so. One of the subjects were tased.
So who's telling the truth? Under KWPD policy, photographs must be taken of all taser probe entrance wounds. Those photos would clearly establish whether Murphy was tased from the front, as claimed by the officer, which would mean Murphy would have seen the officer, or the back, as reported by witnesses. However, the police department has informed the Blue Paper that no such photographs exist. In cases of serious injury, KWPD policy also requires that officers obtain statements from all bystanders. The officers took only 2 independent witness statements that night. Neither give any indication as to whether Murphy knew of the officer's presence. Yet apparently, the incident drew a crowd.
There was people across the street. There was people like ahead of us, and there was people right next to us. The 2 black guys was right next to us. They didn't take their statement. They only took, I think, people across the street that didn't really hear much. They only talked to them. The police didn't.
So the friend, Matthew's friend from Daddy Boom, they didn't take his statement.
Nothing.
And then the two black gentlemen, they didn't take their statement either.
They didn't take their statement.
Because the street was full. There were other witnesses to it. There would have been quite a few statements. There should have been quite a few statements. I know.
We weren't allowed to talk about it. Me and Jason both, we weren't allowed to talk about it. So
who told you not to talk about that?
The police and everybody.
The police told you not to talk about it?
The police said don't talk about it. Just leave it alone.
All right.
I'm not going to name no names, but yeah, back then they told us on the beach, Simonton Beach, just leave it alone, don't talk about it.
It was just a street fight. Nobody ever should have lost their life over an argument that was stupid.